always come back and ask. So I'm Sarah Porce. Thanks everybody for being here. I assume you can see my screen where I just have my logo on there. I don't know if you can see my face at all, but so I'll try not to make faces. I am a lawyer here in West Hartford, and I dedicate my practice to helping homeowners who are in foreclosure. Not everybody who's in foreclosure wants to save their house or can and should save their house, but most of the people I talk to either way need time. So whether you need time to get back on the job and earn some money and show your mortgage company that you can afford your mortgage, and or whether you need time to clean out the 10, 20, 30 years worth of your family's belongings and find a new place to go, I can buy you that time. Everybody I work with, every year I do an inventory of the types of people I've worked with, and really only about half of the people we work with end up keeping their home, but the other half end up happy. So don't think that when you're in, I think the general problem that American society has instilled on us is that when you're behind on a bill, there's something wrong with you. But sometimes that's a strategic decision to not pay your bills and save your money and choose another way to go. So that's I want to sort of talk a lot about that this morning. But the reason I set this up was because of the problem that's going on right now between COVID-19 has caused courts to close. And let me just stop sharing the screen here, and you guys will see my face. Okay. So the Alan, are you sure everybody's in? I'm seeing 3 people. I'm seeing some names, but I just want to make sure that everybody can actually hear this and see this. So can you? Anyways, I'll keep going.
Yeah, everybody's in it.
All right.
I'll tell you, just for good measure, guys, because how technology is, it'd be appreciated if you wouldn't mind jumping on your chats, just saying hello so we can see it.
Okay, great. Just usually I see like more people on my screen. Okay, sorry everybody. All right, didn't mean to interrupt the flow there. Okay, so here's what's going on. I'll put my real quick agenda on the screen. See if I can find it. Here it is. We're going to go through what's going on right now. I'm going to also go through Connecticut's foreclosure process in general. And then for anybody who may not be in foreclosure now or is at the very early stages, I have a COVID-19 and mortgages section of this webinar. Now, I probably won't talk more than a half an hour. It leaves time for questions. And I just want to reassure everybody, that's the point of this, okay? So what's going on is that there's a thing called a law day. I'll get more into that in a minute, but basically if you've gotten a notice that you have a law day and it's been extended, if you had a law day scheduled in March or April or May, you likely got a letter from the court, black and white, real plain, a few lines, that basically said your law day is now on June 2nd. It's been extended or postponed or reset, something like that for June 2nd. Now, a couple of things. So the reason that's a problem, there's multiple reasons that's a problem. One is that's coming up quickly, okay? So you might think, I have till June 2nd. No, you do not, okay? Time is ticking. You only have I wouldn't say you only have a few days. I don't want you to think if you're trying to do something on May 28th, 29th, 23rd, 30th, that's a problem, but you really should get ahead of it, for as far ahead of it as you can, okay? Because the way courts work, and I'll explain that. So one reason is that it's coming up quickly. The other reason is that June 2nd is a Tuesday. Now, in Connecticut, law days are usually on Mondays. Now, in the areas I practice in, which is not Fairfield County, not down in the corner, not the western part of the state, not Danbury or Fairfield County, there are law days typically set by the court on Tuesdays in those courts, but the courts to the rest of the state are always on Mondays. So why is this a problem? Well, because June 2nd is a Tuesday. Now, on the one hand, that gives us an extra day. On the other, it means you can't walk into court on your law day and get help. Okay, so that's the other problem. Let me see what that question was that came through, because I don't want to go too far ahead and miss questions. Okay, sounds good. All right, good. There weren't questions, just letting me know you're there. Thanks, everybody. So the reason this is a problem is that usually your law day, the cases I work on, are on a Monday, and there's also court on Monday, and that's fine. We go in on our law day into court and see a judge every week. every week that there's court, I am in court on a law day. That's fine. People say to me, oh my God, but I don't want to wait until my law day. And we don't. We get moving ahead of time and we get in front of a judge on your law day. So what I'm afraid of so why is this law day different from all other law days, to kind of quote the Passover Seder Haggadah, if anybody out there is Jewish, why is this day different from any other law days? Because it's a Tuesday and because there's no court. Okay, usually you're in court, there's an active hearing with a judge on a law day. And so anybody who got a June 2nd notice, it didn't have a time on it. It didn't have a courtroom location, nothing. So it's not a court hearing notice, and that's what I'm concerned about. I'm concerned that across the state, anybody who got one of these notices thinks that's a court date. But they're going to show up to a court on June 2nd, and there isn't going to be a hearing. There isn't going to be a scheduled hearing. There's going to be no judge available. And the clerks, though, they don't give legal advice. So you might go to the clerk's office and say, what do I do? And the clerks have to say, we can't tell you because we can't give you legal advice. So I appreciate everybody getting ahead of it and getting on this webinar, because I think it's really important to get way ahead of the game. And that's why I'm doing this early and not like next week or the week after. Okay, so a law day is a day that the court sets that's a line in the sand. Okay, so if you have a law day, it's because your case has been in foreclosure for many months. It was probably filed long before. It was absolutely filed long before the COVID-19 crisis, before we even understood what it was, before we even knew it was going to be a problem. So a year ago, 6 months ago, 4 or 5, 6 months ago, and you have a law day because your bank isn't working with you. You have a law day because you were not able to resolve the foreclosure. You have a law day because the bank asked the court to enter judgment, and the court entered judgment and put down the gavel, literally or figuratively, and said, judgment has entered, and I'm setting this law day. Now, the law day is a deadline, and if you do not resolve your foreclosure before the deadline, you will you lose your chance. Okay. Now I want to back up a minute because now I'm getting really deep into this, and I meant to say a few more introductory things. Okay. One is we are recording this, so you can put things in the chat, and you can contact me individually with a question if you're worried about confidentiality. And this is not an attorney-client relationship, and this is for educational purposes. Anybody who is on my email list or has met me knows that I'm constantly just trying to educate people. So this is for educational purposes, and it's hopefully going to give you enough information to let you make the decision, do you need legal help or do you not need legal help right now? Okay, I know there are people on this who do not need my legal help right now. There are professionals of some kind that are just curious about the content, or there are people with a foreclosure case who do not have a law day in place. Okay, so if you're worried that you have a law day, double check your case or ask me if I'm your lawyer. And if you don't have a law day yet, don't worry. Some of the information will be helpful for you in the future. And just keep in mind that taking my advice from here can be dangerous because it's not complete, because I don't know your individual situation. I don't know everything that's been going on with you. So it can be helpful and give you guidance, but usually what ends up happening is I give you enough information to realize it's a little more serious and complicated than you think, and you might need help. Okay, I'm looking over here at my notes here. I don't want to miss anything. All right, so back to what a law day is. It's a date in a case where you don't have equity in your house. Okay, that's really the distinction. A lot of people call me up and they say, I don't want a sign going up on my lawn. Okay, I don't want a foreclosure auction sign going up on my lawn. And my response is usually, you don't get one. Okay, if you don't have equity in your property, if you owe more than your house is currently worth, if you owe more on your total mortgage debt, interest, late fees, all that stuff, then the bank's recent appraisal, okay? If you owe this much and your house is worth this much, then you don't get a sign, okay? You just don't get an auction. The court doesn't even order an auction. Auctions can get expensive. I can explain that too. We're not going to get too much into that. We will be doing a webinar for people who have foreclosure auctions. That will be in a couple of weeks because theirs are all July 25th, okay? So if you had an auction, yours is now July 25th. It was June 6th, and they moved the auctions to July 25th. So we'll do one in a couple weeks. Now the exception to the judge not assigning a law day if you have no equity in your house is if you have some kind of government lien, like IRS taxes, or a HUD lien, Housing and Urban Development lien, and that's usually because you've had a certain kind of mortgage modification that involves a lien being placed on your property by HUD, and that's because you had an FHA mortgage. Okay, so those are very rare exceptions, and you'll get an auction date. But a law day is everybody else who does not have any equity. Now you might say, oh, well, my house is worth $200 and I only owe $190. Why did I get a law day and not an auction? Because if your house is worth $200 and you owe just under that, $190, there's not enough equity to really merit an auction. Again, an auction gets expensive, so the judges are all a little different. Some judges, $10,000 is enough to assign an auction. Some judges, you need $30,000 to assign an auction. Okay, and I don't mean to go down the real details about things like auctions, but I just wanted to throw that in there. That if you're wondering why you were given a law day and not an auction, it's usually you just don't have enough equity. Okay, even if you have a little. All right, so again, June 2nd is coming up, and I think it's a problem because it's a Tuesday, as I said, and there's no court on that day. And I'm really worried about like everybody in Connecticut, and there's lots and lots of people with that law day now. Normally, there's a law day every Monday, meaning only so many cases have law days each Monday, and they're staggered throughout the year. Of course, exceptions are Memorial Day, Labor Day, those Mondays, then those are on Tuesday. But we don't have a national holiday on Monday, June 1st. Everybody's is on June 2nd, and it's everybody who had a law day after about March 15th to now. So that's 6 or 8 or 10 Mondays worth of law days all on one day. And that means lots and lots of lawyers in court, lots and lots of homeowners in court, and there's no court. There's no court date on that Tuesday. So again, everybody's going to think that June 2nd on that notice is a hearing date, and it's not. Because people already think that their law day is a hearing date. I'm in court every Monday, and I see people walk in on their law day, and they say, well, Your Honor, I thought I had a court date today. No, that's, so this is where we get into the details about what you need to do, okay, or what I'm doing for my clients right now. All right, so we had a question before the webinar started, which was, do I file a motion, and what kind of motion do I file? All right, there's a motion so what happened to get a law day is that your case has gone to judgment. Okay, your case has gone to final judgment. And the law day is just this byproduct of that. The law day is probably a month, 6 weeks, typically, when there isn't a COVID-19 with court closures problem, okay? Usually the court will set a law day about 4 weeks out, 6 weeks out, 8 weeks out. And when I work with people, I often get 8, 10, 12, 14, 16 weeks out, okay? I get 2, 3, 4 month dates past the judgment date for a law day. And that gives my clients lots of time to keep working on coming up with a resolution to their foreclosure, okay? Resolutions include modifying your mortgage, selling the house, refinancing somehow, borrowing the money and getting caught up, okay? Or filing bankruptcy, okay? And I'm not a bankruptcy attorney, and if there are questions about bankruptcy, I can answer them to the degree that I can and then refer you to a bankruptcy attorney for the balance of the answer. So what's good about working with a lawyer when you have a house in foreclosure is the judgment enters here and the court sets a law day out here. And I often can get that court to set it out way out here. Okay, so we have 2, 3, 4 extra months to help you resolve the foreclosure. Okay, because a mortgage modification is a complicated process. It's the most common way that I help homeowners solve their foreclosure problem is to apply to the bank to modify the mortgage. You're sending in all of your financial information, and you are asking the bank to recalculate the back payments on your loan into a new payment term, a new interest rate, and to give you a new payment going forward. And what they normally need to do, what the banks need to do when you ask for that, is they need to give you a test period, a trial plan. Okay, you haven't paid your mortgage in 6 months, 9 months, a year, 2 years sometimes. They want to know that you're going to pay your monthly mortgage payment again. They want to know you can handle this big bill. So a typical mortgage modification includes a 3-month trial plan. So you'll get a letter sometime, let's say it was April. You get a letter April 10th. Congratulations. We're entering you into a 3-month trial plan. So your payments are due May 1st, June 1st, July 1st, okay? If you can make those payments, then in July sometime, you're mailed a permanent modification, and you got to review that and sign off on it, execute it properly, and keep making your payments. So that's a typical resolution. Now, it can be complicated because you have to send in pretty much everything financially ever, in the last year or two. Pay stubs, bank statements, tax returns. It's very complicated. But we work with homeowners on that all the time. We take over the document gathering headache. We put the documents together and we correctly submit them to your bank so there's few errors. A lot of people we work with tried to do it on their own before, and either due to a tiny error on their part or just the mortgage servicer being incompetent, they were unable to do it successfully. And we've cleaned it up and helped them successfully apply to modify the mortgage and get into trial payment plans and successfully cross the finish line of completing a modification. So unless all that happens before your law day, okay, it's not enough to be offered a trial plan before your law day. It's not enough to pay 1 or 2 payments before that law day. You have to have it resolved and tell the court and get the bank, either get the bank to file the motion or get a lawyer to file a motion and get the court to open up and vacate that law day or postpone it even further to allow you to complete your mortgage modification. Okay, so it's a complicated process and you don't have a lot of time. And so anybody who hasn't already called me, who has a June 2nd law day, I'm urging people to call me now so that we get ahead of this. We can file a motion. We can say, Your Honor, my client has recently lost their job or suffered some kind of household income decrease because of COVID, and we need more time. And my bet is the court will say yes and give you more time. Okay, I'm confident that if you ask the right way and you get in front of a judge on time, you will get the extension due to the COVID crisis. So that's the good news, is you just need to ask. But you need to know how to ask. You need to ask properly. You need to make sure your motion is actually in front of that judge. So how do we do that? Well, there's deadlines in advance of the hearings. Okay, so the courts really are run by computer now in a way. You file motions. We e-file motions. We electronically file motions. If you're an unrepresented party, if you're representing yourself, you can mail or fax in your motions, and the clerks who are there to process the paper will put you on a court calendar. Now, normally, a deadline is Wednesday at around 5 p.m. or before 5 p.m. each Wednesday to have a court motion, a motion you filed, on a court calendar 2 Wednesdays, or how do I put it? How many days? So the deadline's Wednesday, and your motion won't get on the calendar the next Monday, like 5 days later. It'll be the following Monday, okay, 2 Mondays later, all right? So if June 1st is our deadline, let me grab my calendar. If June 1st is our deadline to file, to get in front of a judge before your law day of June 2nd, you need to get a motion filed by May 20th. May 20th, because that is the Wednesday that is 2 Mondays before June 2nd or before June 1st, and that's June 1st would be your hearing date. Okay. Now the problem is you can't walk into court at 4:55 on May 20th and paper file a motion and get it on for June 1st. It just doesn't give the clerks enough time. So you have to even do it sooner. Okay. Or you have to make sure that the clerks, and right now the clerks are on, they're not even working really. I don't know who's working at the civil courts. They may have a few people in once in a while right now. And if your motion is paper filed, so it helps to have an attorney who has access to electronic filing. Okay, unless you've already set yourself up to electronically file, which you can do as a self-represented party, but there's a process, including having to walk in person to request permission. Okay, so that's one reason why I'm worried about what's going to happen on June 2nd is that I don't know that people know that next Wednesday, May 20th, is really a drop-dead deadline to get a motion filed. And you're really asking to open up the judgment and extend the law day. Unless you have already, in the meantime, resolved your foreclosure because you've been in a mortgage modification, you sold the house or something else, and you just want the court to know. But if that's the case, the bank and their lawyer usually file the motion, okay? So if there are any questions about that, let me take a sip of water. I want you to type anything up or take yourself off mute and you can ask. All right, so if I haven't seen any questions, and if your questions come in, that's fine. I'll catch them in a second. So that is the, I think, sort of why I feel it's urgent to be dealing with the June 2nd law day situation now. Because if you go in on June 2nd, it will be too late. So I wanted to go back to.
I have a question.
Sure.
So I did see a posting on the judicial website that said motions were being taken on the papers only. So how does that affect having a hearing scheduled before your lodging?
Okay, so there have been things filed in foreclosure cases. Okay, the lawyers who represent the banks are working. I'm working, and other lawyers are working. So, and there are judges in here and there. Not every motion that gets filed in a civil case is what we call arguable. Here's the legal term. Here's the lawyer term. Arguable as of right, meaning certain motions just aren't, serious enough to need a person-to-person argument with the bank's attorney and with the judge. So there's certain motions that are arguable as of right, and those that are being filed now, and those are the motions to open judgment to extend your law day. Some of those are being filed now. When a bank files one of those, when a bank files a motion to open, the bank will get it granted. Okay, that's just the way our courts work anyways, is that basically if a bank asks for something, the bank gets it with regard to changing a law day. And that's good news right now, because if you've resolved, I'm getting there, Todd, hang on, it's taking me a minute to answer this. If you've already resolved it and the motion's being filed, it will be heard. What's happening is you're filing what's a document called a case flow request. I've been filing them, the bank's attorneys have been filing them, and that case flow request brings that particular motion to the court's attention so that the court judge will hear it or review it and grant it or deny it without an in-person hearing. Okay, and usually that case flow request, it basically says you put in that why you want the judge to hear it now without a hearing, or you say, like the ones that I have filed, because we've had clients who finished up their modifications in the last few weeks who had a June 2nd law day. And so we've been filing them. We've talked to the bank's attorney, who we said, yep, they agree that we can file this motion. And we say in this case law request, we say, this is being filed on consent. The bank consents. The bank agrees with opening up the judgment. And because the bank agrees, the court can grant this motion without a hearing, or it can review the motion and grant it without a hearing. So that's the little thing you need to do, is file this thing called a case law request. So other motions are being filed also to move foreclosure cases forward, foreclosure cases that have been pending already, that have nothing to do with the virus crisis, that were already in process. So there's other motions being filed, and those will be calendared. I hope I'm answering your question at this point, Todd. Those will be calendared either, when the court's open. Okay, then we'll see the court calendar, the computer at the court scheduling motions on a particular day to be heard. So if you have an agreement with the other party that a motion can be granted sooner, the courts will grant that sooner, and you just have to indicate that in a case flow request. You would still have to file the fee. So the motion to open judgment in Connecticut is a $130 fee. Okay, so you still have to file the fee. Somebody has to file the fee, whether you or the bank's attorney. Okay, so anybody who wants to extend their June 2nd law day definitely needs to get a motion to open judgment filed. Here's the summary. By May 20th, make sure it's processed by the clerks by May 20th. So it means you need to file it sooner if you're paper filing or fax filing. And you need to pay the $130 fee. And they have rejected payment if you send in a check, if you don't have your phone number and your driver's license, number and state on there. I mean, they can be really picky. So I recommend, if you're filing your own $130 fee, to get a postal money order or a Walmart money order or a certified check from your bank or a bank check. Okay, those are good funds, and the court doesn't have to worry about it bouncing. Okay, so that's what they're concerned about. You lose out on the opportunity to pay by debit or credit when you walk in, because you can't walk into the court right now, but you still can pay. But again, if your payment has to be processed, you gotta file your motion sooner. All right, so let me go back to my agenda for a second and make sure I'm covering everything. Okay, the Connecticut foreclosure process. All right, I want to just briefly go over this because not everybody who's on the webinar is currently in foreclosure, or they may just be behind a few payments, or maybe not able to pay right now because of COVID. So generally what happens in Connecticut when you have a mortgage is if you can't pay for 3 months, if you go 3 months behind, on day 90 days, you go day 91, you're considered in default. All right. So if you're a month behind, you can pay to catch up. Pay the payment, pay the late fee. If you're 2 months behind, you can pay a payment with your late fee, and you can stay maybe 1 or 2 months behind. But once you're 3 months behind and you go beyond the due date of that third month, you're not going to be able to pay unless you can pay all 3 months together. Okay. So you can pay 1 month at a time if you're not in default yet. But once you're in default past 90 days, the bank requires you to pay all 3 payments at once. So that's where I usually hear from people is people say, I tried to pay, they won't take my payment. They need me to pay $6,000. I don't have $6,000, but I could give up $3,500. But they say that's a partial payment and they won't accept a partial payment. Why won't they take my payment? And I say, well, it sounds like you're beyond 90 days due, and that's why you need to pay all 3 at one time. And I wish I made the rules. I would not make that rule, but that's the rule right now. So going down the road here, if you're past 90 days and you get to about 4 or 5 months, typically you'll get a letter from a law firm that has been assigned your file. And it's a warning. It's a, hey, we've been assigned your file. We would like you to pay your whole mortgage off. Come on, who can pay their whole mortgage off at that point? Nobody really. So, but that's the letter you're going to get, okay? So you get one of those letters, and it's giving you a 30-day right to dispute, okay? So if you genuinely have a valid reason why you should not be heading towards foreclosure, you can prove that you paid every payment, and your every payment has been accepted by your bank. You have canceled checks proving that they took every payment on time, right? If you have some other defense to being in foreclosure, here's your chance when you get this letter from the lawyer to dispute. You can mail your dispute directly to the law firm that mailed you the letter. You can mail your letter directly to the correspondence address of your mortgage servicer or your bank. You'll flip your bill over, or you'll find somewhere on their website the correspondence address. Okay, not your billing address, not your payment address, not their physical address necessarily, but there's a correspondence address somewhere. And that's where you write your dispute. And you send a copy to the law firm that sent you their letter. All right, I'm being suggested I stop my screen share. Okay, I just didn't want to forget, even though it's a really short agenda. Okay, so you're 3 months behind, they won't take your payments anymore. You go to about 4 or 5 months behind, you get a letter from a local law firm. At 6 months behind is if you haven't prolonged this dispute process. And you don't have to dispute, okay? Not everybody has a basis to dispute, okay? I talk to people all the time who just got that letter from the law firm, and they say, what do? I've got 30 days, and I say, let's talk for a bit, and sometimes there's just no reason to dispute. At about the 6-month mark, you will be served with foreclosure, okay? What does that look like? Typically, for most people, it means you come home one day, and I'm doing this because I've got some papers here, and it's going to be a thick roll of papers or an envelope, and it's going to be either left in your door or in a manila envelope, or it's going to be like on your doorknob with a rubber band or something, okay? So if your kids get home before you do, and you find this thing of papers on the kitchen table or something, a lot of people call me and they go, oh, well, they just stuck these papers in my door. That's not a lawsuit. How could that be valid? Well, that's one of the ways to be served in Connecticut, okay? That's called abode service. You're being served at your abode, your home. So the marshals don't want a confrontation. They don't want to knock and have to talk to you because they don't know how you're going to respond. So they often leave it at your door, and then they note the date and time they left it at your door, and they submit that to the bank, who sends that to the court to prove that you've been served. Okay, so you've been served. What should you do when you get those papers? Call me. Say, hey, I got served. And I'll talk about what's on those papers, and we'll talk about what's going on and what your options are. Okay, so that's what's going to happen at the 6-month mark, about 6 months. Does it have to happen at the 6-month mark? No. The bank can take as long as it wants to start foreclosure on you. Does it have to tell you why it's waiting? Does it have to keep sending you bills? No. You do not need to be notified that you know you're behind and you have rights you have certain rights that you should be told you're in default, but they're not really required to nag you or send you bills all the time. All right, you know you're behind. When you get served, and that's on their time frame. Okay, right now, because of COVID, we may actually be seeing delays in them initiating foreclosures and moratorium on starting a foreclosure, like a complete "we won't do this" kind of thing on the part of the banks. So we'll see. We'll see who's doing what. All right, so it's the 6-month mark. Typically, you'd get served. And on that paper, there's some information. And there's a date on there called a return date. And I want to emphasize that that is not a deadline for you. Now, a lot of these questions, a lot of these details, I go into in short videos on my YouTube channel, okay? So you go to YouTube, type in Sarah Porras, and my channel will come up, and start looking at the they all kind of look alike, and they're all about a minute long. So they're my frequently asked questions. You go to my website as well, and you can find them there. One of them is, what's the return date? Okay, the return date is not a deadline for you. Excuse me. And that is a deadline that the bank sets. The bank's attorneys set that deadline. And that's a deadline for them. Okay, but again, here's the other weird thing, is they're always on a Tuesday. So we get a lot of people walking into courts on the return date that's a Tuesday. So if you're not yet in foreclosure and you get served with papers and you see that return date, that is not a court date and it's not a deadline for you. You should definitely call me before that date so we can make some plans, but it's not a deadline for you. And in Connecticut, we have a mediation program for residential foreclosures. Most foreclosures that are your primary residence, you're the borrower. If it's not a greater than 4-family home, some people live in a multifamily and own a multifamily. If it's 1 to 4 family, and it's a mortgage foreclosure, you will qualify for the foreclosure mediation program, and you have 2 weeks past that return date to apply for the mediation program. Now, if you miss that deadline, that's fine. You can always get into mediation later. It helps if you have a lawyer. But don't think that there's ever a drop-dead deadline, except a law day. Going back to the beginning of this webinar, a law day is a drop-dead deadline. You've got to resolve your problem. All right, thanks for attending. Thanks, somebody has to leave. Thanks for letting us know. The recording will be available, and you can watch the rest of it if you miss any part of this. So the one drop-dead deadline in a foreclosure case is a law day, all right? And again, don't take this as specific legal advice, because there's exceptions to that as well, but I just don't want you thinking if you miss your foreclosure mediation application deadline, that's about 2 weeks after your return date, that you can't ever get in. That's not true. The mediation program is an excellent program. When you're in, you can get, if you're in from the beginning, you get up to 7 months or more of mediation time, and your case does not move forward. So they're giving you 7 months to work on resolving your foreclosure. Typically, that's by way of getting your income back up to speed and applying to modify your mortgage if you want to stay in the house. The mediation program can also be a great way to delay if your plan is to sell or to move, okay? So staying in the mediation program and talking to the mediator and the bank's attorney about your plans for resolving the foreclosure, because you're supposed to explore what are called loss mitigation strategies or options. Okay, loss mitigation. So the loss, however, is on the part of the bank. The bank's not getting paid, so it wants to mitigate its loss of you not paying your mortgage. So that's what's explored in mediation. And so the availability of a modification program for you, the borrower, with your particular mortgage at this particular time is looked at. Okay, they review you for that. The availability of whether, if you want to move, whether you have to short sell your property. Short sell meaning your house is worth 150, but you owe 200. Okay, you owe much more than the house is worth. So if anybody went to buy your house, they're not going to pay what you owe. They're only going to offer about what your house is worth. You'd have to ask the bank for a break. Okay, so that's called a short sale. And that's if you really want to move. That's if you actually want to move. So a lot of people have already talked to their bank. The bank says, we can't modify you. And the bank says, but you can do a short sale. And the homeowner that I talked to thinks, that's great. So I get the call. This is what the call sounds like. Hi, we can't modify our mortgage. We're 5 months behind. We talked to our mortgage company. They say we can't modify, but they'll let us short sell. And I always ask, great, do you want to move? And 9 times out of 10, people will go, no, but the bank said we could short sell. I say, you understand that a short sale is putting your house on the market and selling to somebody and moving out. And they go, oh, we didn't quite get that. We thought it was another way to keep the house. It's not. So that's one of the other options. Let me check this question here. I'll get back to what I think the courts are going to do with the current June 2nd law day. Okay. So let me finish my thought on what mediation's about and the foreclosure process in Connecticut in general. So the other thing you can do if you're in foreclosure in Connecticut, you should be in mediation if it's a residential foreclosure. You should explore modification if you truly feel you can afford to keep the house and you want to keep the house. You can put the house on the market on your own, and it can, if it has to be a short sale because you owe more than the house is worth, so be it. That's doable. There's plenty of buyers out there who are willing to go through that process with you. If you can't sell, so something really wrong with the property, or the bank won't approve of any deals, you can try to do what's called a deed in lieu of foreclosure. A deed in lieu of foreclosure, where you're giving back the deed to your house. You're basically cleaning out the house. So that's the other thing. Not everybody can and wants to clean out the house. It can be a big chore, especially for older or disabled people. So that's an option, to clean out the house and give back the keys, okay, and sign a document. I don't prefer that for lots of reasons, and we discuss that individually with every homeowner we work with, whether a deed in lieu of foreclosure is a good alternative for them. And the other thing you can do is you can file bankruptcy, and there's different kinds of bankruptcy, and I can refer you to a bankruptcy attorney to discuss your options there. Bankruptcy can be an excellent tool for delaying the foreclosure process while you get your income back together. It can be a great tool for getting rid of old, excessive credit card debt or other debt that's preventing you from being able to afford your mortgage payments. And it's a good way to buy some time, okay, and to get yourself financially back in shape. And certain kinds of bankruptcy will recalculate your payment for you and allow you to stay in your mortgage without having to deal with the foreclosure modification process. Okay, now, so that's the foreclosure process in general. If that's a mediation process. If you can't succeed in saving your home somehow, resolving the foreclosure while you're in the mediation process, then the case comes out of mediation and it proceeds to judgment. Okay, there's things that you can file as a homeowner to delay that process. There's things that the bank needs to file to get judgment. But when you're out of mediation, you're back on track to get foreclosed. Luckily, in Connecticut, we do have a judicial foreclosure process. It goes through the courts, and I want you to know that it's not like the day after you're out of mediation, you got to move out of your house. Okay, so it really helps to have someone like me to talk to about timeframes for your case, because I get a lot of questions from people even people I've been working with, and I thought I made it clear to them that they're safe, right? That I certainly would have told them if they had to move out tomorrow or next week. They still say, I'm ready to move. I'm afraid. Is someone going to come and put a sign up, or someone going to come and push me out or lock me out? No, I mean, every case is different, but usually you see it coming, okay? Like a law day, even a law day is not a move out date. I just want to make that clear. A law day is not a move out date. And I can explain that on an individual basis when and if you're someone who's headed towards having a law day put in place. Okay. June 2nd. Now, it's unclear whether the state will really open next Wednesday, May 20th. It's really unclear whether courts will be operational. There's distance issues, right? We're still being required. I mean, the criminal courts have been operating, okay? The criminal matters, domestic violence matters, restraining order matters. Certain things have been in person, okay? And I don't have personal experience with this. I have heard the courts are not handling that well. And that's a shame, because it's the private attorneys like myself, who end up gathered together with everybody in one courtroom with no distancing, and you can't mandate that the guy next to you have a mask on, and that may not even be the most effective method. And the judges are usually somewhere and you're on a screen. So they've got a lot to work out. I'd like to think that they could do it by scheduling it very specifically. These cases are heard at this time, and there's very few people in the courtroom at a time. But we haven't heard what the plan will be. I don't think they will allow law days of June 2nd to come and go if we cannot get in person in front of a judge in some way. Okay, I think that answers the question. If there's no way, because you asked the question about are they hearing motions, without argument, they will not let law days pass unless we can get in front of them and have argument heard. I'm fairly confident of that. So it's possible that June 2nd will be postponed to July 3rd. I don't know what the next, a month out. It's possible. Either because we really can't safely reopen or because the courts haven't figured out how to manage it. Okay? But I don't want people sitting back and going, oh, they'll never open by June 2nd and not doing anything. Don't expect that a June 2nd law day is going to be postponed. Don't expect it. Start working now. This is a gift. I know it sounds weird, but this delay has been a gift. I've worked with multiple people who would have lost their homes in March, April, May, because they had law days set. They never called me before. They never spoke to me before. They didn't call me on time. And miraculously, they're given time now because of the delays that the court is putting into place. So let's use it. Let's use this time. Okay? I'm available. I'm here. I'm working. This is my office. My admin is answering my phone. We have a kind of phone that she can answer from her house. We get messages. We've been scheduling appointments. We've been doing phone appointments. We've been doing Zoom appointments. And I've been retained by several people in the last couple of weeks to work on their upcoming law day. So it's something that needs to get ahead of. Now, you're not wasting any money if your date doesn't go forward on June 2nd. I'm not charging extra if it's postponed. You're just using this extra time to your advantage, and you get access to our assistance for longer. So that's the benefit of getting ahead of it. Briefly, if you're paying a mortgage right now or trying to pay a mortgage right now, I wanted to just hit the sort of the mortgages and COVID-19 part of the agenda. I'll just put this on the screen for a second, okay? I just want you to know that if you cannot pay, you can call your mortgage company. You absolutely should call your bank, your mortgage company, your mortgage servicer, whoever you are working with, to ask for assistance. If you don't call them before missing a payment, you're not going to get on one of their plans. Okay? The last thing I want, and I may get this, and if it's you, fine, don't not pick up the phone. But what I don't want to have happen is have everybody in July back to work. Maybe they missed their payments April, May, and June because of COVID, but they got a letter from their bank saying, you're behind. And if you didn't call before missing the first payment, and now it's May and your second payment is due, call now. It's okay. If you missed April but you didn't tell them why you missed, call them now and say, I'm sorry I missed April, but it was because of this. And if you could show that you went on unemployment, that your hours were cut, that you got sick, they should be able to put you in one of these programs retroactively. Okay? Am I guaranteeing that? No, but ask. At least note the date and time that you made the call. I actually have a worksheet I put together that people can note the dates and the times they called their mortgage company, so that later, like in July, when the mortgage company goes, hey, you owe all your payments, you can say, well, wait, I talked to John, representative number 427, on May 11th at 2 p.m., and John told me, even though I missed my July payment, I wrote it down right here, I can miss my May and June payment, and I'm okay, right? Like, document who tells you what. And you bring that worksheet to me later, you can write it down anywhere, back of an envelope, notepad, doesn't matter. Take notes if you talk to your bank. I'll give you my worksheet if you let me know you want one. And you bring that information to me, at least we can counter what the mortgage company or the bank's going to say. Because they're going to say, no, you missed April, you didn't call us. And so April, May, and June, he's 90 days behind now. Okay, now he's in default. Now we're going to start the foreclosure process. So I don't want it to be a game of gotcha. Okay, document what goes on. If you happen to have already missed a payment and you can document that it's because of COVID, ask for help from your mortgage company now. Call now. You might have to call multiple times. They're getting tons and tons of calls. There's millions of people calling. But just be patient. Call at odd times. Wait on hold and document every call you make. Okay. What's going to happen after? All right. People who've been given right now, people who've been given like April, May, and June to not pay are getting letters that say you have to pay everything in July. Everything. Like all 3 payments plus July. 4 months of payments. So if you get one of those letters, hang on to it. Yes, it might be ridiculous. Yes, you may not be able to pay. But I think that mortgage servicers will put some kind of program in place to make that more manageable. I don't think they're going to start massively foreclosing on everybody who can't come up with 4 payments. It's just not reasonable. But you should save as much money as you can right now. If you can't pay a mortgage payment, maybe you can pay $800 out of your $1,200 payment. Pay it. Okay, that's good for something. Or save it. Lock it down. Don't use it for other things. Don't think, oh God, I got a break from having to pay 3 months. No, those payments will need to be paid. They will come due. You don't get to skip your payments. Okay. Certain banks are letting everybody not pay. Certain types of loans have better protections than other types of loans. If you know you have an FHA loan, if you know you have a Fannie Mae or Freddie Mac loan, you're getting a little bit of more protection than a conventional loan or someone through a credit union. Okay, but that doesn't mean you get to skip a payment. Okay, there's no bailout for you. There's no break. All right, so I just want to be clear about that. I want you to do as much as you can to prevent it being hard at the back end. If you can pay something now or save money now, it'll make it easier come July, August, September, whenever this is technically over. Because when it's technically over, you may not have your job back. You may not be back to full time. But your mortgage company is going to say, your state is open. You got to pay. All right. Let me go to this question, and please feel free to ask any other questions. Someone asked, is a motion to open judgment and extend the law day considered arguable? Yes, I'm sorry if I didn't make that clear before. A motion to open judgment and extend your law day is an arguable, as of right type of motion. Okay? That's why I believe they will not allow law days to pass. This is my belief. They will not allow law days to pass until we can get in front of a judge and actually argue a motion. Okay? Remember, if you've resolved your foreclosure and you or the bank have filed a motion saying, hey, it's all set, we both agree our judgment can be opened and our law day can be vacated, completely gone, not reassigned, then that motion can be heard and doesn't need to go in front of a judge. But the kind where you want more time and the bank says, no, we're not giving you more time, you've had plenty, that I think you deserve a in-person hearing, okay, just to preserve your constitutional rights. That's my little opinion. We'll see how the court manages it. All right, so it's going to remain to be seen, and that's why I'd like the court to delay it beyond June 2nd. It's just cutting it a little close. So that, I think, is all the material I was planning to cover today. Obviously, my big push was to emphasize how urgent it is to get way ahead of June 2nd. I'm available. I'm here all week. I'm here all next week. I'm in every day. We've got someone answering the phones. Please leave a detailed message if you call and you have to leave a message, because we will get right back to you as soon as we can by the next morning generally. So, especially because I know these things are time sensitive. All right. Anybody have any more questions, you can either ask in the chat or we have been recording this. I have a friend, Alan, who's been recording it at his end. I'll make sure that he either gets me it, and I've been recording it myself, so I'll try to post it as well, and I'll send out the link to the attendees today. All right, so thanks everybody. Let me know if you have any questions. Please make sure you're welcome. Please make sure you have my information. You can chat if you need my info. I can I'll put my, does it have my phone number? Yep, it has my phone number on it. Just go to sarahporce.com to contact me through my site. Now, I have a tip sheet. Forgot to mention this. I'm going to give this out to you. Let's see here. If you'd like this as well, I can email this to you. I have it's 4 or 5 pages. It just kind of gives you some high points. Scrolling through it. Sorry if it's not really readable at your end at this point, but you can see it's got a lot of questions, facts about foreclosure. A lot of the stuff I covered today is just summarized in these few pages. So please let me know if you'd like that. And I think I have everybody's email who registered today, and we can just send that out to everybody. So All right, let me make sure I got all the questions. I'm just being thanked. You're welcome. Thanks again for attending, and stay in touch, everybody. Thanks a lot.